Welcome in lecture 4.2 of the Legal and Governance series. In this additional lecture, I will not present any new content, but I will connect some of the slides that are presented in the legal part to some of the governance issues that are involved. Of course, this is not covering all stuff that's possible, it's just giving a few examples of how things that appear in the legal context also has relevance from the governance perspective. Now this first slide is on land use planning. You have seen it appear in the lecture on this topic. We don't have to cover all of it. The important thing I want to draw your attention to that in general, your ownership protects you and gives you the right to do things that you want with the land. But there is an exception, and of course there is the possibility of government interference, and it's important to see that this is a public activity. As also indicated in the text marked red, no one shall be deprived of his possessions except in the public interest and subject to the conditions provided by law. So this indicates the example that we also discussed, that if there is government intervention, it's public intervention, it always has to be, decisions have to be made in the public interest, not in the private interest of those that are involved. And decision making itself is also subject to all kinds of procedural rules, and they are specified by law. So yes, the government can do all kinds of things, but they are bound by the rules of the law themselves. Now if we look into the procedures that govern decision making in this sphere, you can see an example here. Again, we don't have to discuss the different steps. What is important is that there are all kinds of procedures that have to be followed in order to make decisions. You see it here in land use planning. Of course, you've seen lots of them in infrastructure planning as well, which is also a typical example of the public sphere, where governmental organizations can take all kinds of decisions, but are bound by all kinds of procedures in making those decisions. Now let's move from the hierarchy model to the market model. And of course the typical legal instrument here is that of the contract. So contract law is the first topic that's important here, and of course here you can see the basics: freedom to contract whomever on any subject in any form, and that of course relates to the rules in the institutional model that we discussed. So contract with whomever is the idea of open boundary rules, so everyone is able to enter the market, there are no market barriers. Any subject means that there is open scope rules, the scope of what you decide about is open, and what you can do in which way you do it is also open, which implies open authority rules. So here you can see that those rules that we discussed in the institutional model refer to this basics idea of contract law. And of course there's a second point that's important: consensualism. The mutual consent takes decisions. That's aggregation rule, aggregation by consensus. If you agree that a deal is made, that you have a contract, then it's set, and that is the aggregation rule. So both parties have to agree on the deal. Now you all have been studying, of course, the traditional model in contract construction law, where design and execution is separated. So you first have a design contract and then an execution contract. We've seen that as a typical idea of the individual model in markets. So design and building are separated, they don't combine the work, and you have separate contract with designer, and later after that with the construction firm. You also see that there is supervision involved, and that of course is what we discussed under monitoring in the transaction cost economics part. So all the costs that are made for supervising is connected to this monitoring of the work. Now the last bullet point may confuse you somewhat, because here it's indicated that there is a hierarchical relationship in the traditional model, and of course we are thinking about markets here. But it's important to understand that there is a difference between the different phases that we are talking about. So when we refer to markets, we refer to the selection of the people you are going to work with. Here we have competition, and this is of course before the contract is signed. So before the contract there is obviously no hierarchical relationship, but there is competition under market conditions on who gets the deal. Of course, when the contract is signed during the execution of the work, temporarily there is a hierarchy. So in this case, the one who has taken on the deal has to do the work. And that's the contractor. And you as the employer, you are in the position of the hierarchy. And you can decide what has to be done. Of course, in accordance with the provisions that are made in the contract. And the next thing that is important to understand this idea of hierarchy is that after the contract there is a termination of the relation. So once the building is finished, you have no relation anymore. So this is of course in line with the idea of markets as a model of governance. So it's important to understand that if there is a reference to hierarchy, this is only during the contract and during the actual building process. So yes, there is some element of hierarchy, but it's not durable, for instance, if we talk about the relations. Now this idea of hierarchy is present in this clause of the standard conditions. The contractor shall execute the works in accordance with the drawings to be provided and approved by the employer's agent, shall comply with the instructions and directions given to him. Of course, this is the idea of hierarchy during the contract, during the building process. The, so to say, employees, the constructor, has to act in line with the decisions of the boss, and of course the boss is the employer or his agent. The idea of markets also becomes obvious in this clause, where it is about relation between the consultant and the client. The client is bound to keep all data of a consultant as confidential. Of course, this is an information rule, and it indicates that actors usually do not share information, particularly, of course, not to competitors, because you don't want that information to be spilled over to your competitors. Now, a model that is different is, of course, that of the building team. The idea here is that the design is made by a traditional designer and a contractor. So they combine their work, and of course that's the idea of networks. However, the contractor is not sure of execution, and that of course refers to markets, and it has to do with procurement law that we will talk about in the next slide. So procurement law ensures that those contractors that were present and helped in making the design are not sure of execution. Another point that is important is how the legal provisions are for mistakes. When, of course, the design is made together, the question arises who is liable for mistakes if the design has been a cooperative job. What you see here is typical of the fact that there is legal individualism. In legal terms, it's always an attempt to ensure that single persons, individuals, are to be made responsible for what is happening. So there is no collective liability, but it is for one of the members. The member with the wrong idea, unless it is in the other member's field and he accepted it. So you can see that from a network perspective, you would expect that there is like common liability because, again, you did this together, you cooperated. But in legal terms, this is something that is seen as very difficult, and they always want to draw apart the liability of the different partners. I already indicated that procurement law was very important in governing relations, for instance, between designers and constructors if they have worked together. And the basic idea of European procurement law is that it is generally driving towards markets. You can see that in the assumptions that are here: eliminating barriers, so freedom of movement, that's markets and goods and services. And the idea behind it is that if you remove barriers, it improves economic welfare in all the member states. So this is the idea, that markets are there to create competition. If there is competition, this will create efficiency and thus welfare. So it's important to understand that this is the basic assumption of procurement law in the European Union. The idea of markets is also present in this directive, where it indicates that the award, the decision to give a job to someone, has to comply with certain principles, particular free movement of goods, freedom of establishment, freedom to provide services. Of course, that's markets, as well as the principles deriving from that: equal treatment, non-discrimination, mutual recognition, proportionality, and transparency. And of course, this is directly against the idea of networks, because usually in networks you have all kinds of selective mechanisms that you use only for members. Yes, you give specific information to members only. The selection process is from within the scope of the members of the network, and not from all the possible competitors of those members. So here you can see again that these rules of market governance are directly in conflict with the rules that you would use under network conditions. Here we see another example of provisions that are aiming for markets and competition. If someone, for instance a construction firm, has been advising the contracting authority, for instance a municipality who wants a building to be built, has played a role in advising in setting up the tender, the contracting authority shall take appropriate measure to ensure that competition is not distorted by the participation of that candidate or tenderer. So the candidate cannot apply anymore. Again, you can see that this is an example that is driving to competition and not to network involvement, because of course the idea of networks is that you work together, and of course if you work together in setting up a tender, you most likely would like to be involved in the tender itself. This is comparable to the idea of the building team, where we saw that if you as a contracting firm also were involved in making the design, of course from a network perspective the obvious strategy would be that the same contractor that has played a role in the design would also be the one to use the knowledge that they shared in doing the actual building process. But as we saw there, again, procurement law makes sure that this is separated. So it is making it very difficult to really get involved in network relations in these situations. Now let's move to some situations where we do find network relations, and this is of course in the sphere of public-private partnerships. Here you see the different organizational models that have been distinguished. Those at the outside, the public land development and the private land development, are not really network kind of relations. The other three are. We will discuss them. Now at the left of the scheme we saw the organizational model of the public land development, where basically the municipality develops all the land and does all the work developing it. So there's no real cooperation, there's just the sales. So this is basically the idea of hierarchy. The public organization does the work, does most of the work itself. Of course there is a sales transaction, and that might be done under market conditions, but the question is not on how the buildings are built, but how the land is developed, and that is done by the public organization. At the far right of the scheme we saw private land development. Again, there is no real cooperation between the different partners. Here the private company does merely all the work. Of course how they do the work, that's decided by the developer himself, so he might have his own technology to do that. He might also hire people to do the work. That's his own decision. Of course, there is some payment of services that are done by the municipality, so some things are developed by the municipality, but of course there is no sales transaction here, not a real sales transaction. Of course there's money involved, but there is the monopoly. Of course only the municipality can do that part of the job. Again, the basic important thing is that this is not really network governance, because there is no real cooperation. The next model is that of the development rights model, where there is an agreement between landowners and the municipality, and they make some agreements on how they do the work and what shall be developed. So there is a transfer of land, but again, the transfer comes with the right to develop buildings on that land later on in the process. So then the municipality prepares the land for construction and transfers the land back, and then the developers can do their work. Now the important thing is here that there is some, although limited, cooperation in making agreements on what to do. And we see that also in these specific characteristics. So it is a model that's often used, but the developers in the municipality consult about the program to be realized, and they make agreements about that. So again, this is how we can see that there is some form of cooperation here. The other model with limited cooperation is the concession model, where land is usually transferred to a developer, and the developer develops the land, but they make agreements again using certain conditions for the redevelopment. So the program lines, urban planning conditions, you see the stuff that is there. And of course a financial agreement will be part of this as well. So there is, again, a lot of the work is done by one of the parties, in this case the developer, but the way that they do it is under certain conditions that are made agreements about in advance. These characteristics that we just discussed are also provided in this slide from the concession model, where you can see that the developer does a lot of work in developing the public space, but they have made agreements on how this is going to be done and what the basic characteristics of what the public space will look like, and the fixed financial arrangement that comes with that. So again, this is an example of limited network cooperation. Now the last model is that of the joint venture model, where the different actors really work together within a specific organizational relationship that is the joint venture. They combine each other's resources, and of course they share the risks. So in the other two models that we discussed, the risk was primarily with one of the partners. Here the risks are shared, and of course the idea here is that this is like full network cooperation, where you combine your resources and your responsibilities, and of course also the profits that might arise are also for the different partners. Now the joint venture model is not the only model that can be used in order to have some form of network cooperation. We see here also the legal instrument of a contract between the municipality and the developer regarding a land use plan. So there is first a land use plan agreement, and this agreement between the public organization and the private one has all kinds of provisions on what the plan will look like. It is on the content of the land use plan to be drafted. There is first this private law agreement, and then the public law land use plan. Of course, it's important to understand that making and deciding about a land use plan is a public organization task, and of course it has to be done under the conditions of public law. And so the mayor and alderman cannot formally make an agreement with private partners on the land use plan, because that land use plan has to be decided by the municipal council. So the only thing that they can do is that they will prepare they will do everything that is required to have it, and that they will they try to make sure that this land use plan will be decided by the municipal council. So what they do is that the public executive binds themselves to one private actor. And of course, this is really counter to the idea of public law decision making, because public law decision making has to be in the public interest, and in the general sense, the municipal council has to be free to decide whatever they think is in the best public interest and not in the interest of one organization, one private sector developer. So you can see that there is some conflict here between this time between the public law or the hierarchy arrangements and the network governance rules that you would like to use. Okay, that's it. Time to wrap things up. I gave you some examples, some illustrations of how the same governance issues that we discussed in the governance part of this course are also treated and discussed in the legal part. And of course it's obvious that you would expect that, because the legal provisions are also about the governance of the process. The only difference is that we start looking at them from a different perspective. So they cover, in many cases, the same type of issues, but again, from a different starting point. I hope this has been illustrative, and I hope that they enable you to also see in all other kind of legal provisions that the governance issues that we discussed are also relevant here.